When the Constitution was first created, women did not have the right to vote. In 1848, the first Women's Rights Convention was held in Seneca Falls, New York. At the convention, the Declaration of Sentiments was made, which outlined grievances and set the agenda for the women's rights movement. Later in 1869, Susan B. Anthony and Elizabeth Cady Stanton created the National Women's Suffrage Association, which pushed for a female's right to vote. In 1903, the National Women's Trade Union League advocated for improved working conditions and wages for women. Finally, in 1920, the 19th Amendment was ratified, granting women the right to vote. A number of Supreme Court cases can be used to illustrate the growth and progression of women's rights and equality in the U.S. The first Supreme Court case that we'll be talking about today is Miller v. Oregon of 1908. The state of Oregon passed a law in 1908 that limited women's workday to a maximum of 10 hours. Muller, a laundromat owner, ordered one of his female workers to work more than 10 hours. Oregon convicted Muller on behalf of violating the law. Oregon's law was then brought to court to discuss whether or not it was constitutional. Louis D. Brandeis was hired by the state of Oregon to argue that a shortened workday for women would be crucial in promoting their health. Brandeis also discussed that a tiring, taxing workday could be harmful for women. Is it constitutional to set a maximum amount of hours that a woman can work per day? Does the Constitution uphold that a limited hour of work is beneficial in protecting the health of female workers? The Supreme Court was unanimous in upholding the Oregon law. The law was passed during the Progressive Era when the government was striving to improve industrial work conditions and women's health. The Oregon law was seen as constitutional, as its intentions were to promote women's health. Future legislation was created to promote the general welfare, women's health, and create safer work conditions. Such laws did not discriminate or limit the opportunity of women. After the Triangle Shirtwaist Fire in 1911, people of the United States made a huge outcry to improve work conditions, increase sanitation and safety in the workplace, and create a system of more fair treatment for working women and children. Congress was responsive and passed legislation reflective of the public. Now on to Griswold v. Connecticut. Griswold, director of the Planned Parenthood League of Connecticut, gave information, instruction, and medical advice to married couples concerning birth control. She was convicted under Connecticut law, which outlawed birth control and birth control counseling. Does the Constitution protect the right of marital privacy against state restrictions on a couple's ability to be counseled in the use of contraceptives? The Supreme Court ruled 7 in favor of Griswold and 2 in favor of Connecticut. The Supreme Court stated that the Constitution provides some privacy rights. Collectively, the First, Third, Fourth, and Ninth Amendments created a new constitutional right: privacy in marital relations and a couple's right to plan a family. This case led to a broader interpretation of right to privacy, as well as an expansion of couples' rights, privacy, and a woman's control over her body. Later, this ruling expanded to unmarried individuals having the ability to purchase contraceptives and seek counseling. Today, birth control is covered by the Affordable Care Act. Additionally, this case acted as a precedent and framed the ruling in the Roe v. Wade case, which legalized abortion. The Idaho Probate Code specified that males must be preferred to females in appointing administrators of estates. After the death of their adopted son, both Sally and Cecile Reed sought to be named the administrator of their son's estate. The Reeds were separated. According to the Probate Code, Cecile was appointed administrator and Sally challenged the law in court. Did the Idaho Probate Code violate the Equal Protection Clause of the 14th Amendment? The court ruled unanimously that the law was unconstitutional and violated the 14th Amendment. The court argued that to give a mandatory preference to members of either sex over members of the other, it is to make the very kind of arbitrary legislative choice forbidden by the Equal Protection Clause of the 14th Amendment. This case affirmed that under the 14th Amendment, gender discrimination or gender bias is unconstitutional. This case acted as a precedent for future cases and framed public policy. Examples include the Equal Pay Act, Title VII, Title IX, and it added strength to the Civil Rights Act of 1960. A Texas resident by the last name of Rowe terminated her pregnancy via abortion. Although abortions were illegal in the state of Texas, except to save a life, she was convicted under Texas law. Does the Constitution support a woman's right to have an abortion? The Supreme Court ruled 7 in favor of Roe and 2 against. A woman's right to a pregnancy and an abortion is upheld in the Constitution under the right to privacy. The final ruling gave women full control over her body for the first trimester of the pregnancy. After the first trimester, abortion rights are up to the state's discretion. This case expanded the right to privacy. The Supreme Court stated that the right to an abortion is outlined by privacies guaranteed by the Constitution, specifically the 4th and 14th Amendments. This case served as a precedent for future cases. For example, the Supreme Court upheld a woman's right to abortion but added more restrictions. In the rulings of Planned Parenthood of Southeastern PA v. Casey, Webster v. Reproductive Health Services, and Sternberg v. Carhart. Ida Phillips filed a lawsuit against Martin Marietta Corporation. The company was not accepting applications from women with preschool-age children, but did accept applications from men with children the same age. She said that she was denied employment from the corporation due to her gender, which is a violation of Title VII of Civil Rights Act of 1964. Can a business have a different hiring plan for women with preschool-age children than it does for men with preschool-age children? The court unanimously ruled that employers cannot refuse to hire women with preschool-age children while hiring men with children of the same age. This ruling gave strength to and further enforced the Title VII of the Civil Rights Act of 1964. This case gave power to the Equal Employment Opportunity Commission. The EEOC has the authority to investigate charges of discrimination against employers who are covered by the law. If discrimination is found, the EEOC tries to settle the charge. If unsuccessful, the EEOC has the authority to file a lawsuit to protect the rights of individuals and the interests of the Pittsburgh Press v. Pittsburgh Commission on Human Relations. The city of Pittsburgh had a human relations ordinance that prohibited newspapers from carrying help-wanted advertisements designated job preference by gender. The National Organization for Women filed a complaint with the Pittsburgh Commission on Human Relations about a violation of the ordinance. The National Organization for Women stated that the Pittsburgh Press Company violated the ordinance by listing employment opportunities under the columns designating job preference by gender. Pittsburgh Press Company argued that the ordinance violated the First Amendment rights. Does a city ordinance forbidding newspapers from carrying help-wanted advertisements in gender-designated columns violate the freedom of speech and of press guaranteed by the First Amendment? The Supreme Court ruled 5-4 that employers' use of male help wanted and female help wanted advertisements in newspaper columns is unconstitutional because sex-segregated columns enable employers to express unlawful gender preferences in hiring. This Supreme Court case ruling affirmed that the First Amendment rights are limited when it is used to express gender discrimination in employment or hiring. This type of speech is a violation of the Civil Rights Act of 1964. Employment opportunities are now segregated by skill and education, but not by gender. Again, this case gave strength to the EEOC in Title VII. Craig versus Boren. An Oklahoma law prohibited the sale of non-intoxicating 3.2% beer to males under the age of 21 and females under the age of 18. Curtis Craig, a licensed vendor, challenged the law as discriminatory. Did an Oklahoma statute violate the 14th Amendment's Equal Protection Clause by establishing different drinking ages for men and women? The Supreme Court voted 7 in favor of Craig and 2 in favor of Oklahoma. The court stated that Oklahoma relied on insufficient statistics and made generalizations about drinking habits that did not suffice. Also, the Supreme Court referred to the 21st Amendment, which did not alter the Equal Protection Clause, as all genders were treated the same under the law. Under the 14th Amendment, different genders can't be held to different standards, which includes standards based on age. Future laws made cannot hold men and women to different standards. Additionally, this law negatively impacted commerce. Meritor Savings Bank versus Vinson. After being dismissed from her job at a Meritor Savings Bank, Michelle Vinson sued her boss, Sydney Taylor. Vinson stated that she was sexually harassed by Taylor, who created a hostile working environment. Did the Civil Rights Act prohibit the creation of a hostile environment, or was it limited to tangible economic discrimination in the workplace? The Supreme Court ruled unanimously in favor of Vinson. The court stated that Title VII was not limited to economic or tangible discrimination. The court interpreted that Congress intended to strike an entire spectrum of disparate treatment of men and women in employment. This case expanded protections guaranteed under the Civil Rights Act of 1964 to include intangible discrimination. The EEOC issued guidelines that specified that sexual harassment leading to non-economic injury was a form of sex discrimination prohibited by Title VII. Sex discrimination includes the creation of a hostile or abusive work environment. United States versus Virginia. The Virginia Military Institute was a male-only institution. The United States filed a lawsuit against the state of Virginia stating that their exclusion of women at the institution was unconstitutional. It was claimed that the male-only institute violated the 14th Amendment as well as the Equal Protection Clause. In an effort to reverse the lawsuit, the state of Virginia announced that they were planning to open a similar institute for women, titled the Virginia Women's Institute for Leadership. The United States still took this lawsuit to the Supreme Court. Is the 14th Amendment, including the Equal Protection Clause, fulfilled in the creation of the Virginia Women's Institute for Leadership as compensation for their counterpart, Virginia Military Institute? In a Supreme Court vote of 7-1, the Virginia Military Institute was deemed unconstitutional because it could not provide the same educational advances as the Virginia Women's Institute for Leadership. Additionally, the VWI was not created to level the opportunity for men and women, but rather to fulfill the 14th Amendment. The Institute for Women would not provide them with the same opportunity as men at the Virginia Institute. This set a precedent for institutions to come on making the education equalized. In 2003, Congress passed the Partial Birth Abortion Ban Act. Dr. Leroy Carhart and other physicians who perform late-term abortions sued to stop the act from going into effect. Doctors argued that late-term abortions are okay because it is protected by the undue burden standard of the Planned Parenthood v. Casey case ruling. The plaintiffs also argued that the act's lack of an exception for abortions necessary to protect the health of the mother rendered it unconstitutional under the Supreme Court's decision in Steinberg v. Carhart. Regardless of the Congress's findings in the act that partial birth abortions are never medically necessary. Is the Partial Birth Abortion Act of 2003 an invasion of personal privacy because the act does not permit abortions in an effort to save the life of a mother? The Supreme Court ruled that Congress's ban on partial birth abortion was not unconstitutionally vague and did not impose an undue burden on the right to an abortion. Because the majority found that the act applies only to a specific method of abortion, it held that the ban was not unconstitutionally vague, overbroad, or an undue burden on the decision to obtain an abortion. The court preserved the precedents set by Casey v. Sternberg. The Supreme Court upheld the right to privacy and a woman's right to abortion. However, restriction was implemented. The court ruled that partial birth abortions are an unconstitutional method of abortion. Women may still have an abortion, but not through this method. Roe v. Wade has been upheld. However, collectively, a string of cases has imposed limitations and restrictions on a woman's abortion right. While a woman still maintains the right to an abortion, there are more strict guidelines since the ruling of Roe v. Wade. As you can see, women have come a long way in the United States. The Supreme Court has defended the rights of women and pushed for equality. The Supreme Court still stands to do so. Today, we see females attending prestigious universities and achieving extremely high positions in employment. Despite the long way that females have come, some still argue that women are treated unequally in the United States. According to an article published by the Daily Beast, for every dollar a male makes, a woman makes 77 cents. Today, we see many people continue to push for women's equality in the workforce and society. This is demonstrated through various means. Despite how one may feel on this topic, there is no denying that women have come a long way since the creation of the Constitution and make a valuable impact.
J.R. Sean Kingston. You're way too beautiful, girl. That's why it'll never work. You have me suicidal when you say it's over. Damn, all these beautiful girls, they only wanna do you dirt. They'll have you suicidal.
Who run the world, girls? Who run the world, girls? Girls, who run the world, girls? Who run the world, girls? Who run this mother? Who run this mother? Who run this mother? Who run this? Yeah, that's right.